The main topic of discussion today will be how to get a high grade on your upcoming contract law exams or assignments. There is a set of rules that applies to all the exams in law that you need to be aware of. Maybe you have heard about them, but most of the times these rules are overlooked, and unfortunately, this is the main cause of lowering students' grades on law exams. Students often forget to analyze their exam requirements. What this means is that you need to know exactly what is required from you to do, and therefore, then you need to plan your revision accordingly. For example, if you have a set of 6 questions to answer on your exam, that means that you can revise 6 topics, but it's not very recommended for you to revise all the 6 topics, everything you have learned on the course. It's more recommended that you do some selective studying, choose the topics that you understand the most, that you feel more comfortable with, and then plan your revision accordingly. Selective studying has been the way to succeed for students that has achieved a first class in law. So it's very important that you use this tool, but you should also be very careful to use it very carefully, because sometimes you may omit the topics that you need to be revising. So you need to be choosing the topic with very carefully and then planning the revision for your upcoming exam. If you don't have an exam, but you have an assignment instead, that is easier, so you should feel lucky. If you have an assignment instead, you can just read your question and apply normal problem question or essay question style to answer your question. Also, it's very, very important that you follow your professor's guidelines. It cannot be emphasized enough how grading can be subjective most of the times. So if different professors may have different case lists on the same topic, or they may have a little bit different approach to how you are required to answer a problem question or essay question. So my recommendation would be to try to get as much feedback as possible from the professor. What does your professor consider as a first class? Or what does your professor consider as a 2-1? I also suggest you to ask for model answers that your professor specifically has graded as a first class or a 2-1. So it's very important that you work with your professor to maximize your chances of getting a high grade according to the requirements specifically on your course and on your university. Today's topic of revision will be consideration and promissory estoppel, because this is the topic that comes up very often on contract law exams and courseworks. Firstly, we will go through the general principles and cases that you need to know to be able to successfully answer a problem or essay question on consideration. Afterwards, we will discuss an example problem question on consideration and how you should be answering it. Consideration is a badge of enforceability for a contract. For a contract to exist, there has to be an offer, acceptance, consideration, and intention to create legal relations. Consideration is the third step of creating a contract, because law does not enforce gratuitous promises. For example, the simplest example is that A provides B with services, A gets money in return. Money itself is the consideration. However, it doesn't have to be money all the time. It has to be something, but it doesn't have to be money. Therefore, if A provided B with services, but did not get anything in return, there would not be any consideration. In a problem question, you need to look for the consideration, and you need to point the examiner what you understand or what you understood from the facts to be consideration. In a problem question, you cannot use common language to define consideration. You need to use a legal principle. And with everything in a problem or essay question, you need to be defining every legal principle that you're using for your arguments with a legal authority. For consideration, it's very often used this case, Curry versus Mesa. You may have another case on your lecture slides that you can use. That's absolutely fine, as long as you use a proper legal authority to define consideration in a problem question or essay question that you have. In Curry versus Mesa, it was stated that considerations of a valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. If you have an in-person exam, you would need to memorize this definition if you are not allowed to take the notes. But if you're allowed to take the notes, then you don't have to memorize it, but you need to have the definition of consideration on your notes so that you can use it in a problem question or essay question. First thing to prove in your answer would be to show where is the valid consideration. In order for you to do that, you need to be aware of the basic rules. Past consideration will not be a good consideration. The case where this principle was established was Mercado. Consideration must move from the promisee. And thirdly, consideration must be sufficient, but need not be adequate. We will go through each of these rules in detail. A promise which is made after an act has been performed is generally not enforceable, as it is not subject by consideration. So once the offer and acceptance is made, consideration has to come straight after. It cannot be after the act promised has been performed, because if that's the case, then it would be past consideration, which is not a good consideration, as per the case of Mercado. In Mercado, there was the work on the house had to be completed before the agreement had been signed. Therefore, this was past consideration. However, the promisee did not have the payment in mind when she completed the work. Therefore, she was not entitled to the payment. If there had been an understanding that the work would be compensated in some way, then work would have been consideration. There are some exceptions to this rule. Pao On versus Lao Yulong, and this was the case where it was argued that past consideration will be good consideration when the past act was done at the promisee's request. The parties clearly understood that the act was to be remunerated, and the promise would have been legally enforceable had it been made in advance. So in certain circumstances, it can be a good consideration, but you need to, if you see that there is a past consideration on your problem question, that is straightforwardly an indication for you that this is a legal issue that you need to be addressing. First, you start with Mercado, which is the general principle that past consideration is not a good consideration. Then you consider the exceptions. Does any of the exceptions apply? Like this one, was the act done at promisee's request? Or did the parties understand that the act would be remunerated? If any of these principles apply in the problem question, then you can apply the exception. After the discussion of Mercado and the exceptions, you need to make a conclusion. What would be the most likely outcome? Would there be a valid consideration? Would the exceptions apply? What is the more likely outcome? You're not required to give a definite answer, because nobody knows a definite answer in law. It's not math. There is no one right answer. But you really need to give the arguments and show to the examiner that you understand the law very well. You can make credible arguments, and you can advise the client in the problem question as to what would be the most likely outcome if this case went to the court. Another rule is that consideration must move from the promisee. So if somebody else promised remuneration, a third party, that would not be a consideration. So you need to watch out this fact when you read the problem question. Did the consideration move from the promisee? This gives the contract an exchange reciprocity element. If A promises B something, B has to provide consideration. Finally, consideration must be sufficient but need not be adequate. This you most probably will come up in the problem question, this legal issue. So it's very important that you understand the main principles around this rule. What this basically means is that consideration need not have an economic value. A good case that shows this principle is Chappell versus Nasser, where they received 3 chocolate bars as a return, not any money, and even the 3 chocolate bars were considered to be a good consideration. Therefore, it does not have to be money. Consideration can be many different things as long as it's something given in return. But what exactly can that be? You need to look at the cases. So there are many different cases that gives you many examples of what could be consideration if it's not money. And if when you're arguing a case in the problem question, you need to be giving the relevant examples, the examples that are factually similar to the facts that has been given to you. Chappell versus Nestle is very commonly cited in problem questions when it comes to this legal issue of consideration being adequate and enough. Consideration is often mixed with promissory estoppel in the problem question. So if you decide to revise this topic, it is very important that you also revise promissory estoppel. Promissory estoppel is when a creditor promises to accept a lesser sum in full settlement and the debtor relies on the promise by altering his position. Estoppel operates as a principle of equity to stop a creditor from going back on his promise and insisting upon his strict legal rights. Estoppel protects the reliance interests even in the absence of consideration. It is seen as a flexible way of achieving justice. There are 3 steps that you need to show in your answer for promissory estoppel to be successfully established. First, you need to show that the party promised the other party something. There has to be a promise. Then, the second step of the test is reliance. You need to show that the party that has been promised something relied on that promise and somehow altered their position so that they suffered some detriment. Example problem question that you could be getting on these topics can be the following. Michael owns a number of studios in Birmingham. He's letting one of his apartments to an engineering student, Irene, for £1,200 per month. Following the second installment in her rent, she fails to pay Michael. Michael is furious and informs her that she must leave. Following a negotiation, he decides to let her stay for £1,000 until she finds a job. 3 years later, she has still not found any job and is still paying a decreased rate. 1 year ago, Michael was in a car accident, lost his legs, and Aaron has been taking care of him whilst also cleaning another studio for Michael. So this is just an extract from a problem question that we have on the website that you can view here at this link. You will receive the slides as well as the recording of this session afterwards, and you will be able to go in more detail. The first issue here is to discuss where is the consideration. As we said, you start from the definition. What is consideration according to Kobus? It means that you place in your answer the definition of consideration, and then you apply it to the facts of the case. According to the definition, do you think that consideration exists on the facts of the case? Irene provided consideration by paying rent in exchange of the room she was renting. However, the problem arises when Irene gets a lowered rent because she can no longer afford it. So the rent itself is a consideration, and there are no controversies over that. However, the problem arises when they change the agreement so that she pays a lower rent. Has there been a consideration for lowering the rent? That's the main legal issue here. She does not give anything in exchange of the new contract. The new contract is the lowered rent. Therefore, there is no consideration at this point, and you can cite any of the cases that supports your argument. Here we have cited Chappell versus Nestle. The second issue is discussion of if cleaning and cooking amounts to consideration. Consideration has to come from the promisee at the time of the promise that the promise is made. Application of this rule here would be that Michael reduced rent from Irene. She did not give consideration right at that time. So she started cleaning and cooking not right after she got the reduced rent, but sometime after. So that makes it difficult to apply this rule. She started cleaning and cooking for him 2 years after her rent was reduced. Therefore, it's unlikely to constitute consideration. There are also other legal issues to be discussed on this problem question, and you can see the full question and answer at this link here. The recommended notes that you should be reading is for consideration and promissory estoppel. Most of the contract law exams that we have seen in our practice, and we have seen thousands of students, we have helped thousands of students get high grades. Most of the times, consideration and promissory estoppel arises as a problem question in contract law exams. So it is highly recommended that you revise this topic. How can we help? It is very important that you have the right simple study materials for you to have the best chances of achieving high grades. That is why we have hired content creators that are the best law students and graduates who have achieved high grades in their respective law exams, and they've been in your shoes very recently and they have achieved success. All our study materials have been designed specifically to give you the best chances of getting high grades, and specifically first class. It is full of exam tips and our advice of how to get a high grade in the simplest way possible, and we highly recommend that you get access to our simple study materials by getting our premium subscription. If the resources we provide are not enough, you can also get one-to-one tutoring session. One-to-one tutoring session helps students to get more personalized support. It is 1 hour meeting with one of the tutors where you can raise any issues that you're struggling with, whether it's a general preparation for exam, or even if it's a specific question that you have and you don't know how to start, you don't know how to do legal research, anything it is, our tutors will be able to help you, and it will be like dedicated personalized support for an hour. You can get more hours if you need after the first tutoring session. We have helped thousands of your students to get high grades, and we really hope that you will be our next success story. You can see our reviews as well. If you'd like to be the next student to get high grades, please join SimpleStudying now. Thank you very much.